are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Let us try to analyze ano ang ibig sabihin ng progressive scheme of taxation sa Constitution. Ano ang ibig sabihin nito? Okay, ang ibig lang sabihin nito is whenever the Congress is enacting a tax law, alright, they should try their best to address their intention to the ability to pay principle of the people. Okay? So they should come up with many rates from the lowest to the highest. So that is what we call progressive scheme of taxation. So you will see na ang ating income tax tumutugma sa progressive scheme of taxation because sa tax code, ang income tax rate ng individual taxpayer
action by which a party sues another for enforcement or protection of a right or prevention or redress of a wrong. So what are the keywords here? Enforcement, protection of right, prevention or redress of wrong. Tandaan nyo, enforce, protect, right, prevent, redress, wrong. Okay. Remedy by which a party seeks to establish three things: status, right, particular fact. Okay. Ano yung sa television, yung commercial? SRP. Ano yung SRP? Suggested retail price. So tandaan nyo, to establish
This is before the amendment. And for every allegation, it should be supported by evidence. Because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish to the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial affidavits.
is our definition of the practice of law. We have three very good definitions of the practice of law. The practice of law is a profession. It is not a business or trade. Lawyering is not primarily meant to be a money-making venture. And law advocacy is not a capital that necessarily yields profits. Duty to the public service and to the administration of justice should be the primary consideration of lawyers, and gaining a livelihood is a secondary consideration. Very good definition, easier said than done. So our primary consideration is to administer justice. Gaining a livelihood is a secondary consideration only for us lawyers. Another definition of the practice of law is
in Spouses Minjola versus Court of Appeals, the Supreme Court devised or laid down tests in determining whether a counterclaim is compulsory or permissive. There are 4 questions to be asked, my friends. The first question is, you check. Okay? Sabi ko, compulsory or claim arises out or it is necessarily connected with transaction occurrence which is the subject matter of the complaint. Pag sinabi mong compulsory counterclaim, kaibigan, it is an offshoot of the complaint. There is a logical connection between the counterclaim and the subject matter of the complaint. Kaya sa bar exam, tinan nyo ang 4 na test na ito. Number 1, are the issues of fact or law raised
what is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are two aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act a violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
Now take note under Rule 58. There are two kinds of injunction: preliminary mandatory injunction, preliminary prohibitory injunction. Now, lifetime of a TRO issued by the RTC, by the Court of Appeals, and by the Supreme Court. So, if it is issued by the RTC, you have 20 days. Within the 20-day period, then there shall be a hearing. The hearing is mandatory as regards to the application for preliminary injunction, either mandatory or prohibitory. Now, after the lapse of the 20-day period and there is no injunction issued, it becomes factus officio. Now, as far as Court of Appeals is concerned, the lifetime is 60 days. Now,
what is involved is what appears to be a discriminatory act on the part of government or agents of the government. The proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory act.
First, let us speak of the principles of generality and territoriality. Remember that questions about these two principles were asked in the 2015, 2017, 2018, and 2019 bar examinations. Okay? So far as generality is concerned, consider the persons which are exempt from the general application of Philippine criminal law by virtue of the principles of public international law, and the person exempt from criminal from the application of Philippine criminal law are the sovereigns, chief of states. We have ambassadors, ministers plenipotentiary.
When party rests his case and real evidence consists of objects offered in court. Example, you may use a physical object to demonstrate its existence or identity. Like for example, the serial number on a computer found in a private residence could identify it as a government-owned property. Or for example, the gun that was used in case of murder. Now, the other type will be testimonial evidence. And what is testimonial evidence? You call a person to take the witness stand and his testimony is being offered to prove specific purposes. The third type will be your documentary evidence. It is formally offered by the proponent immediately before he rests his case. A document may be an object evidence or a documentary evidence depending on the person.
In the Constitution that the JBC, the Judicial and Bar Council, shall be composed of 7 members. The Chief Justice as ex officio chairperson, the Secretary of Justice, very specific, as a member, ex officio member, and then a member from Congress, and then 4 other regular members, a representative from the retired Supreme Court justices, very specific, a representative from the integrated bar, a representative from the private sector, and then a representative from the academe, professor of law. This case of Chavez versus JBC, it's included in this slide. I'm sharing simply because there was an issue actually on what a member.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way. And we are VLC.
What is a dispute? The dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between two persons, natural or juridical. In the Republic Act 9285 or the ADR Act of 2004, it is defined as a process or procedure used to resolve a dispute or controversy other than by adjudication of a presiding judge of a court or an officer of a government agency, in which a neutral third party participates to assist in the resolution of issues, which includes arbitration, mediation, conciliation, early neutral evaluation, mini trial, or any combination thereof. So we take note of the meaning. It is a process or a procedure.
Now take note under Rule 58. There are two kinds of injunction: preliminary mandatory injunction, preliminary prohibitory injunction. Now, lifetime of a TRO issued by the RTC, by the Court of Appeals, and by the Supreme Court. So, if it is issued by the RTC, you have 20 days. Within the 20-day period, then there shall be a hearing. The hearing is mandatory as regards to the application for preliminary injunction, either mandatory or prohibitory. Now, after the lapse of the 20-day period and there is no injunction issued, it becomes pactus officio. Now, as far as Court of Appeals is concerned, the lifetime is 60 days. Now,
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way. And we are VLC.
If what is involved is what appears to be a discriminatory act on the part of government or agents of the government, the proper right to invoke there is the right to the Equal Protection Clause. Because remember, the right to the Equal Protection Clause is a right against any kind of discrimination or discriminatory act on the part of government. So that is a broad formula. So if what is involved, I repeat, is an act of government that appears to be arbitrary, whimsical, capricious, oppressive, unreasonable, confiscatory, and you want to challenge that, you invoke your right to due process law. On the other hand, the Equal Protection Clause is a guarantee against any kind of discrimination or discriminatory act.
We have also these provisions in the Constitution indirectly affecting taxation. One is due process, and there are two aspects of due process: procedural due process, and of course, the substantive due process. You know what is procedural due process? Well, if the imposition of a tax requires certain steps or legal processes to be followed, well, failure to follow them would make the act in violation of due process. One good example here is the assessment of taxes by the Bureau of Internal Revenue or by the government, where the procedure is laid down under Section 228 of the National Internal Revenue Code. So, any deviation from those rules would be a violation of procedural due process.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way.
This is before the amendment. And for every allegation, it should be supported by evidence, because evidence is the means sanctioned by the rules in a judicial proceeding to establish what? That equals to the truth. So if there is an allegation supported by evidence, then you're able to establish the truth. But now it has been adjusted. Kindly take note of that. Why? Because today, for purposes of filing a pleading, for purposes of initiating a complaint, and this would include all other pleadings, even responsive pleadings, what is now the requirement of the rule under Rule 6? That together with the pleading, initiatory pleading, which is made as an integral part thereof, would be what? Judicial agreements.
Good day to our dear attendees from different parts of the country. I pray that you're all in great state of health. This free webinar is streaming live via the Villages Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of Villages Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of Villages Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser, using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.villageslawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual class and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Our lecturer has obtained his Bachelor of Laws from the San Sebastian College of Law. He started his legal career as an associate lawyer of the Rufus Rodriguez Law Office. After his legal training therein, he worked as a litigation lawyer of various banks and even became the head of the legal department of the Land Bank of the Philippines Leasing Company. In 1994, he joined the Academe by teaching at the San Sebastian College of Law, PUP, New Era, RVR College of Business and Commercial Law Department of the De La Salle University. He is the author of the Notes and Cases on Banking and Allied Law, and he is also one of the distinguished lecturers of the Mandatory Continuing Legal Education for Lawyers. He is currently the managing partner of Villasys Law Center Law Office. Without further ado, ladies and gentlemen, Professor Larry P. Ignacio.
Good day to everybody. This is the virtual law companion of the Villasys Law Center. Welcome. Lend me your ears. I will be talking about the changes of in the revised 2019 Revised Corporation Code. This is Republic Act number 11232, which is known as the Act providing for the Revised Corporation Code of the Philippines. In my talk about the changes, I have divided it into two parts. The first part is called as the fundamental changes under the Revised Corporation Code, and the second part will be the so-called technological changes. Fundamental changes because, well, they are changes that are completely different from the old code. I also called it technological changes because the modifications in the Revised Corporation Code integrated the technological changes that we have now, such as video conferencing, webinar, similar to what we're having right now, and similar changes. Our talk will run for about an hour or so. Should you have some comments, if you have yes comments, there is a comment portion for that purpose. Feel free to give your comments. I also wish that I look good in the camera. This is the first time that I'm doing a webinar, and that's one of my wishes. Another thing, of course, is that you're going to hear my audio loud and clear. With that, again, welcome to the Virtual Law Companion. Let us therefore start with our little talk about the changes of the Revised Corporation Code. As you will note, I called it as a peek at the changes of the 2019 Revised Corporation Code. Let me go to the first part, the fundamental changes. I listed about 11 of these fundamental changes. I'm going to start with the first one. It's about the incorporators. We recall that under the old code, there's a requirement regarding incorporators. Among others, incorporators should be natural persons, and there's a minimum number of incorporators, which is a minimum of 5. Under the modified change, under the 2019 Revised Corporation Code, there is now a removal of the minimum number of incorporators. And unlike before, partnerships, associations, or corporation, and notice singly or jointly with others may now form a corporation. The first fundamental change. Second one, we now have a so-called one-person corporation, also known as the OPC. The new code allows a single person to organize and put up a corporation. Of course, when we say a single person, we're referring to the number, not to the status. Let's talk more about the one-person corporation. As I've said, it's called as OPC. Now, who can be a one-person corporation? The code says there that the single person who must form a one-person corporation must be a natural person, a trust, or a state. A further requirement states that the natural person must be of legal age. So these are the entities that are allowed to form a one-person corporation. If there are entities allowed to form a one-person corporation, the code provides for entities not allowed to form a one-person corporation, and they are enumerated as follows. Banks, that's one. Non-bank financial institutions. We have quasi-banks, pre-need trust and insurance companies.
Villasis
We
Law
have
Center.
public and publicly listed companies, non-chartered, government-owned or controlled corporations. And there's also a mention about natural persons licensed to exercise a profession. They are not allowed to organize a one-person corporation for the exercise of that profession, and unless, of course, there is a law allowing the same. So we now have entities allowed to form a one-person corporation and those that are not allowed. Let's take a look at some of the unique features of a one-person corporation. Notice here that a one-person corporation is not required to have a minimum authorized capital stock, but with exception, unless otherwise provided by special law. Second, they are not allowed to submit and file bylaws. The single person shall be the sole director and the president of that one-person corporation. Regarding officers, please take notice that under the old code, there is a prohibition regarding dual positions. The 2019 Revised Corporation Code specifically mentioned that a single stockholder may not be appointed as a corporate secretary. What about a single stockholder also being the treasurer? The code states that a single stockholder can be a treasurer, but he must post a surety bond. These are some of the unique features of a one-person corporation. When you form a one-person corporation, there's also a requirement that a nominee and alternate nominee must be designated. The said nominee and alternate nominee must give their written consent when they are designated as such. These are the requirements under the Revised Corporation Code the purpose of having a nominee and an alternate nominee. This will take charge. They will be in charge of the corporation in the event of death or incapacity of the one-person corporation. In line with the one-person corporation, there's also a provision stating that the registered with the SEC for the purpose of conversion. After complying with the requirements, the SEC will now issue a ordinary stock corporation as well. Like conversion into OPC, the requirements that will be provided by the Securities and Exchange Commission must be duly complied with in order for that conversion to take effect. Are you hearing me loud and clear so far? Kindly press V if and when you're hearing me loud and clear. Welcome for your comments again. So that basically is what is a one-person corporation. Notice, it is indeed a fundamental change from that of the old code. Let's go to the next fundamental change. This change pertains to the term of a corporation. Let us recall our old code again. We all know that the old code provides for a 50-year term of a corporation, which may be extended, of course. Right now, that 50-year corporate term was removed. With the present setup, we can say meron na raw forever, because a corporation will exist perpetually unless sooner dissolved or unless there is a provision in the Articles of Incorporation regarding the term of that corporation. So, again, meron ng forever insofar as the corporate term is concerned. The same provision providing for the removal of the corporate term also integrated that practice that in the event of failure to extend the lifetime of a corporation, it may be revived. I mean, so there is now a provision providing for the so-called revival of corporations. This is when, as I've said, if there's a failure to extend the term and it died a natural death, the remedy there is to provide, rather to revive the corporate existence. And when it will be revived, all the rights and privileges under the certificate of incorporation of that corporation will remain. Similarly, the duties, the debts and liabilities will remain. So it is just and reviving the old corporation. A unique feature once a corporation is revived is that it will have a perpetual existence unless in the application for revival there is another term that is provided. This is revival of corporations. Again, are you hearing me loud and clear? Give a comment. I want to see your V, the letter V. Or if you wish, you may type VLC. Next one. There is no more any minimum capital stock that is required. Because of this, anybody can start a business with a little capital or funding. This is the Section 12 of the 2019 Revised Corporation Code, where
Villasis Law
it
Center.
specifically stated that minimum capital stock not required of corporations. For a particular purpose, the SEC will be providing the capital stock. But as mentioned in the Revised Corporation Code, as I've said, anybody can already start a business, even if you have no capital or if you have less funding. That's the fifth change. Number 6. You notice that corporations are now allowed 5 years from incorporation to commence operation. Unlike the old code where you must formally organize within a period of 2 years. Otherwise, you will suffer the consequences of failing to organize. You know what I mean. This time, it's no longer 2 years, it's 5 years. Number 7 change. The old corporation code previously provides for a staggered term for trustees in non-stock corporation. This time, the corporation code stated that trustees shall be elected for a uniform term of not exceeding 3 years. There is an added requirement, and there's now a mention about corporations vested with public interest. And here, it is provided that if you are a corporation vested with public interest, there's a requirement or an added requirement that an independent director must be appointed. The independent directors, they will constitute at least 20% of the board. The code also mentions what are classified as corporations vested with public interest. So that is the number 7 fundamental change. Number 8, officers of the corporation. We all know that there are 3 major officers of a corporation, namely the president, the secretary, and the treasurer. Of all of these officers, it's only the corporate secretary who is required to be a resident and a citizen of the Philippines. In the 2019 Revised Corporation Code, the treasurer is now required to to be a resident. Apart from that change, there is an added officer required when it comes to corporations vested with public interest. They must designate a compliance officer. So this is the one of the, well, or major officers when it comes to all corporations vested with public interest. The other provisions regarding corporate officers will remain. Let's talk about the board next. That's number 9. The revised corporation code already provides for the so-called emergency board. What is an emergency board? As the name implies, the corporation, in the event of some urgent matters or emergency, may already act on the same. Of course, we are aware that the board can only act properly and appropriately if there is a quorum. Without a quorum, it cannot practically perform its duties as such. There's a need to, if there's a vacancy, there's a need to fill up the vacancy, and when there are requirements in filling up a vacancy, it may be filled up by the shareholders or stockholders or by the remaining board. That may take time, and that may be a tedious process. So there will be a possible problem if the corporation needs to act on an emergency, but without a quorum, as we said, it cannot proceed. Right now, the corporation can be more decisive in times of an emergency because an emergency board may be created in the event of a vacancy and if there's no quorum. The purpose, of course, is to prevent grave prejudice, grave, substantial, and loss to the corporation or any prejudice because of this possible failure to act on an urgent matter or an emergency. Again, this is one fundamental change, and it provides for the creation, the election, and duration of that emergency board. If there is a vacancy, the new code states that the vacancy must be filled up within a period of about 45 days. Right now, it says there that to create an emergency, the vacancy may be filled up from the officers of the corporation through the unanimous vote of the remaining directors or trustees. The purpose of creating that emergency board is limited only to the emergency action that is urgent or necessary. That emergency board will have a term for purposes of acting on that emergency or to look at the provisions of the code. The term shall cease within a reasonable time from the termination of the emergency, which we stated a while ago as the purpose of creating that emergency board, or upon election of the replacement of the vacancy. It says there whichever comes earlier. But our point is the only reason for creating that emergency board is to act on that urgent or emergency. Again, to prevent possible loss damage or prejudice to the corporation. There's a further requirement that when an emergency board is created, the SEC shall be notified within a period of 3 days. The SEC shall likewise be informed of the reasons for creating that emergency board. That's the number 9 change. Comment again. We go to the next one. The next one pertains to the provision in the Articles of Incorporation or the bylaws. And I suppose the reason for this change is to help decongest courts. We all know that
Villas's Law Center.
the jurisdiction of the SEC regarding intracorporate disputes was already transferred to the regular courts, thereby giving more cases and additional burden to the already congested regular courts. Under the revised corporation code, disputes between and among the corporate officers among stockholders may be settled by arbitration, and this will be integrated as among the provisions of the Articles of Incorporation or the bylaws. Nonetheless, please take note that disputes involving criminal offenses or the interests of third parties are not, or rather they remain non-arbitrable. They are not subject to arbitration. This is not included in the old corporation code. As I've said, if there are disputes intracorporate, this will be settled by filing that case in the regular courts. We have now commercial courts, which are the regional trial courts. Number 10 change. The corporations of old are prohibited from making corporate donations for political parties or candidates. Notice that this is already lifted, or yes, not included in the 2019 revised corporation code. Right now, that prohibition on corporate donations for political parties or candidates is only limited to foreign corporations. With this, if you are not a foreign corporation, you're allowed to make corporate donations for political parties and candidates. This is the section 35, paragraph I of the revised corporation code. May stress that corporate donations to political parties or candidate for purposes of partisan political activity is only limited to foreign corporations. Are you hearing me loud and clear so far? And again, do I look good on camera? I hope so. The last fundamental change that I have noted pertains to these corporations vested with public interest. As I've said earlier, the 2019 Revised Corporation Code provided for what are corporations vested with public interest. Apart from that, it added additional officers. We mentioned earlier about a compliance officer. And apart from a compliance officer, there is also a requirement regarding independent directors. Since it is a corporation vested with public interest, there is an added requirement regarding monitoring, so that a corporation vested with public interest, they are required to submit additional annual reports to the SEC, particularly a director, trustee compensation report, and appraisal or performance report. Well, that is because they are corporations vested with public interest. A closer monitoring and more corporate officers, compliance officer again, and independent directors. So these are again the 11 fundamental changes that I have noted under the 2019 Revised Corporation Code. There are other changes, but as I've said, I simply focused on the fundamental or the major changes. That's the first part. The second part, I called it as the technological changes. As I mentioned, in view of the technological advances that we have now, the provisions of the 2019 Revised Corporation Code availed of these technological changes for possible convenience of the corporate officers and also of the board. And because of these corporate changes, it is now possible for shareholders and members of the board to avail of these technological advances. Remote communication is now possible through video conferencing, teleconferencing. They can also vote in absentia, not limited only to proxy voting of all. In the board, well, yes, it's a practice before the revision, the changes in the 2019 Revised Corporation Code, that the SEC allowed participation in board meetings via remote communication. These are already integrated and they form part of the provisions of the 2019 Revised Corporation Code. So, as I've said, I have listed 5 of these technological changes. Let's start with the first one. Now, it pertains to the manner and voting of directors or trustees. It is now allowed that the stockholders may vote through remote communication or in absentia. Remember, well, before, this is only possible through proxy voting. Well, you will appoint a representative to vote for and in your behalf. That is no longer limited to proxy. Remote communication or absentia or voting under absentia is now allowed. Second, technological change. there are instances when actions of the board will require consent of the stockholders, either through a voting of the stockholders 2/3 or 3/4 or as required. The consent of the stockholders in such instances may already be acquired by means of electronic means. Among the changes where consent of the stockholders, the
Villasis
extension,
Law Center.
the
Villasis
shortening
Law
of the
Center.
corporate term, the increase or decrease of the capital stock. Basically, these are those changes mentioned in Section 6 of the Corporation Code. By the way, that provision in Section 6 is retained under 2019 Revised Corporation Code. Just to recall, Section 6 provides for instances where even non-voting shareholders may be allowed to vote. Anyway, going back to these provisions of the Revised Corporation Code, as we said, the consent in these changes may already be possible by means of electronic means. And even notices of meetings, regular or special, may be sent via electronic mail or such other matter. As I've said, we have integrated the technological advances that we have now. Well, I hope you're also hearing the barking of my dog. Hindi ko mapigilan yan. But make a comment. I'll try to stop that barking of the dog later. Number 5, rather, that's the third one. So, of course, before going to number 5, we have to take a look at the number 4, technological change. Board meetings. Board meetings. Attendance in board meetings is possible via remote communication. So, video conferencing, webinar, like the one that we are having right now. And if you're going to attend remotely, that is, you will be counted in the yes, kasama ka sa quorum, I mean. The SEC already provided for the regulations for purposes of attending board meetings through remote communication. That is still in place. Finally, nasa panghuli na po tayo. The number 5 change is the monitoring and filing system. You can already apply online. You can already register online. It would now be easier for us. Well, especially with the situation now, bawal ang personal interaction. So we can do it online nowadays. The SEC will be developing, and we can visit the the website of the SEC for the purpose of filing online. What are the requirements? What are the matters that will be, what are the requirements for this purpose? So there you go. 2 parts, fundamental changes, and the technological changes under the Corporation Code. Should you wish to know more about seminars, webinars that may be conducted by the VLC through its virtual law companion, kindly visit and check out our sites as well. The site of the VLC Law Center. Contact numbers, the link, the website will be provided if you are interested to know more about this. And yes, may I share to you that VLC is also conducting webinars or lectures via online in their Bari Review Center. And please visit VLC for more details on the matter. Thank you very much. Stay safe and healthy. And also, stay focused. Maraming salamat. I hope that I have shared something about the 2019 Revised Corporation Code. Thank you for listening. Hope to see you next time. Goodbye for now.
We are VLC. We offer value, providing you with quality review programs and online seminars that bring out the best in you. At VLC, we listen. Adapting to the times, we brought our in-demand on-ground review lectures online with our virtual law companion. Subscribing to this online learning platform means you get 24/7 access to our updated video lectures and bar review notes from the best and most respected lecturers and professors. At VLC, we collaborate, working with the best technology providers through our learning management system to best prepare you for the first ever digitalized bar exams. We work hand in hand with legal experts you can trust, providing top-notch services to those who need it the most through our free online legal consultations and free lecture series. Value, listen, and collaborate. This is the VLC way, and we are VLC.
Let us try to analyze ano ang ibig sabihin ng progressive scheme of taxation sa Constitution. Ano ang ibig sabihin nito? Okay, ang ibig lang sabihin nito is whenever the Congress is enacting a tax law, all right, they should try their best to address their intention to the ability to pay principle of the people. Okay? So they should come up with many rates from the lowest to the highest. So that is what we call progressive scheme of taxation. So you will see na ang ating income tax tumutugma sa progressive scheme of taxation because sa tax code, ang income tax rate ng individual taxpayer